So hello everyone. Thank you for joining Privacy Talk. I'm so glad to have Lior from Israel. He's exclusive lawyers in their protection the privacy space. So Lior, thank you for joining us today.
Thank you for having me. Nice to be here.
Great. Then first of all, I'd like to share his profile. Lior advises on various aspects of GDPR and Israeli privacy law, working closely with businesses to improve their information governance in this rising field. The practice includes advising on compliance privacy aspects in commercial agreements and corporate transactions, internal policies, organizational measures, engagement with vendors and other third-party users. Also in life science and online companies. Lior also provides a day-to-day legal advice on corporate securities and commercial law, mostly to technology and life science startups, and advising entrepreneurs in various types of the business transactions. Strong background and experience in advising the public companies traded abroad, mostly in the US, regarding securities, regulatory measures, and corporate governance. So again, it's a pleasure to meet with you here.
Thanks. It's my pleasure to be here. Yes, what am I doing? I'm head of data protection and privacy practice at EBN, Erdinast, Toledano. It's a large law office in Tel Aviv. We are a very known and acknowledged law firm. This practice, actually, this is my startup. I came here to this office to establish the practice, and I'm the founder of this field here. Actually, it's great times to be part of the privacy community in Israel because we will talk about it soon. We also have a very large reform in privacy laws in Israel. But yes, data protection is my passion. Before that, I was a commercial lawyer, dealt with the high-tech M&A and even securities. And I did it for some time, and I loved it. But somewhere after GDPR broke to our world, and also made some changes in Israeli market as well, especially in the tech industry at the beginning. And that's where my attention came to privacy, and the rest is history, actually. And yes, this is what we're doing. We are working closely with Israeli companies in privacy compliance and day-to-day issues, and then the commercial engagements relating to data or around that data. And a lot, we are also working in cybersecurity incidents in Israel, reporting duties to the Israel Privacy Protection Authority, and of course, IT agreements that are also part of this practice. Eventually, everything that comes with complexities over data in commercial and day-to-day business, we are leading. And of course, M&A transactions and high-tech transactions, investment transactions that involves privacy due diligence. This is also our part. Every transaction today almost involves some sort of data protection and privacy compliance issues. So we are there as well.
Yeah, that's very amazing. And you kindly explain us that the legal firm is doing and work with the startup company as well. So could you share about a bit of your history as well? And maybe you became a legal expert. So is there any opportunities you decided to become a lawyers to support some of the companies? So that's very helpful. You shared your history about it.
Yeah, so as I said before, I came from the commercial arena, so I'm a corporate lawyer at first, and that is why when I came to data protection and privacy, it was quite natural because it has a very stronghold in the commercial law arena. I think that when it comes to conflict, dispute, and litigation, there are some lawyers that also are coming from there to privacy, but I think it's a very different approach. Eventually, we are enablers. Privacy lawyers, privacy counsel, we're enablers. We're trying to make data to be part of a transaction and monetization of data. So we are actually enablers, and we are trying to build and trying to enable data to move from one side to another, or to monetize it, or to use it wisely, and all of those still to protect the privacy rights of people, data subjects.
Yeah, thank you for sharing. That's very important to work on a data protection from the legal perspective at this moment. And you belongs to the very exclusive law firm this moment, and as you explained at the beginning. And could you share about your law firm, especially for any unique points that you are providing to the clients, and also yourself? Then, so could you share about it?
Sure. And well, first of all, UBM, we're a very known and acknowledged law firm here in Israel. And we're working with all the big actors in Israel, but we also work closely with international companies and a lot of foreign law firms, foreign companies, investors, small and big. They all know us, and we're working together here in Israel. And of course, we're practicing law in Israel, so we're working what is relevant for Israeli market. But there are a lot of foreign actors that are coming here to Israel to invest or to build or to make purchases. And of course, most of the Israeli high tech, I think maybe it's 90% intended for export. So we are also looking outside all the time. That is why we are addressing GDPR and other standards that are relevant for the target market of our clients. Now, I think that eventually one of our strong points, first of all, we're doing everything to make the client as covered as possible, of course, very diligently. And we also find or try to find creative solutions. As I said, I think that maybe we can say that we are enablers. We're trying to make the business to work and to do it lawfully and under the requirements of the law. And we also, I think that it's kind of one of our features that we are very collaborative within our law firm, meaning that I'm not working alone. I can go to my partner here at labor law department and ask him questions, or work to competition law and ask my partner ask her advice, and we're working all the time together. And I think that it provides very good synergies, and this is also part of our job.
Yeah, that's a brilliant, and that's your comprehensive support might be very good for the companies to start in a business, not just only in your country, but also to collaborate with your country's the businesses. That was a very impressive opportunity. So thank you for sharing your work. As for the next question is for the transitions. I just encountered your own post on LinkedIn that is very helpful for the privacy community, because you mentioned the Israeli privacy laws is becoming changed, maybe almost some decades. So could you share about the next question? So how has been discussed the Israeli privacy law so far, and what will be the new amendment will we bring out? So could you share about the idea?
All right, great. Thanks for asking. Indeed, maybe the most interesting thing that is happening now in privacy laws in Israel. And generally speaking, the Israeli privacy protection law is from 1981. And since then, it was amended for several times, but I think the last time was more than 10 years. And eventually, the law was it was very good, but it it was eventually it was approved in 1981, and so and Israeli privacy laws in the last years are relying not only on the statute itself because it was obsolete and archaic, and we had to rely on new standards. Some of them were came from the market, bottom up. Usually, market went to see the GDPR and the requirements, the standard requirements globally, and we brought them to Israel to interpret the law. And others, of course, other factor is the guidance of the Privacy Protection Authority, which is the supervisory authority in Israel. And eventually, Israel is an adequate country under the European Commission resolution from 2011. And right now, they just finished an audit of a few years. And one of the flaws that they found during this audit is that Israeli law must be changed to adapt to the new era, new standards, new market requirements, and all the things that we were interpreting and relying on guidance and market and best practices. It's time to put them in the written statute. So I think that we also have, by the way, another important legislation in 2018. The information security regulations went into effect the same month as the GDPR on May, and that was also a very important legislation, but it was not enough. So now amendment number 13 actually is doing a huge reform in privacy laws. Many of the things that were, as I said, were not written now will be within the statute itself. But I think that you can say that there are a lot of things, material issues, very interesting. But I think that the most important one is that the authority itself will now have vast power and enforcement powers, especially enforce and to impose financial sanctions and administrative proceedings in a scope that was not there before, and it will turn the Privacy Protection Authority into a very strong regulator that will be able to enforce its decisions, will be able to impose financial sanctions on corporations and individuals. And I think that it will, first of all, it will protect better the privacy rights of the Israeli public, but it will also elevate the processing of personal data. Entities will follow much closely upon the requirements of the regulations and the law itself. And it's going to be a very, very interesting time that we're facing. And the law itself is actually supposed to pass today at the last reading, the Knesset, the Israeli parliament. And after that, we will have 1 year until it will enter into effect. I assume that the big players, the large companies and public entities will probably use this year more thoroughly to adhere to the requirements, the new requirements, and the rest of the market will follow them. This is how it goes usually in regulation and regulatory compliance. And if you want to review a little bit of the changes, aside of enforcement and sanctions, and I can say a few things. For example, a data protection officer will become a mandatory requirement for certain organizations. Until now, it was voluntarily only, but for now, it's going to be mandatory. You can say more or less for the following: data brokers, public entities like governmental-owned companies and authorities, and also for organizations who are processing personal data on large scale, very similar to GDPR requirement. and also other organizations which are also processing mass amount of very sensitive information. It's like special category information, but it is not their main business. For example, a hospital. The main business of a hospital is to provide care for its patients. But a hospital naturally is processing a lot of personal health information. So this organization will be subject to the DPR appointment requirement, as an example. Another big issue in Israel, similar to the UK, we had a registration requirement for database owners. It's like if you want to compare it, as if a controller would have to register with the regulator to provide some sort of notification once he's starting to make processing of personal data. So they narrowed down the registration requirement, I think maybe 95%, leaving only very specific organizations under the registration requirement. Also, another thing, as I said, a lot of terms and definitions have been changed. Personal data term, or processing, or even identifiable person. All of those are now part of the law, and of course the definition of special categories data. We have something else. We have specially sensitive information, which is the similar to special categories of GDPR, which, by the way, contains specific local values that were important to the local legislator. For example, salary information, which is not part of other definitions abroad in the US or in the EU. Another thing, evaluations of employees and candidates, professional evaluations. These are part of the especially sensitive information in Israel. Very interesting because these are specific issues that were regarded as such by the legislator. Other things, we have changed the criminal offenses. The list of the offenses was changed to provide more emphasis on places whereby a person is intentionally making unlawful processing or deceptive behaviors, deceptive processing, or deceptive basis to obtain information for a personal data for a person. Sorry, and of course, a lot of authorities and powers for the regulator. Now, maybe two other interesting issues. I think that as opposed to the current law before the amendment, now the law also contains a revised purpose limitation principle. The purpose limitation was broadened, and now the principle is a little bit, it covers more areas of the law as well, and also disclosure requirements. Once for a processor or a controller that is collecting data, now there is an increased disclosure requirement. Of course, that all of those, there are additional issues, of course, but let's say these are maybe the big ones. And all of those issues are making a very, very interesting and broad change for the market. I think that generally speaking, Israeli companies are aligned with adequate data protection principles, as you can find in Europe, for example, and even California, maybe. I think California, they went after the Europeans, but eventually you can find a very good sense of adequate data protection in Israel. But now it's going to be under the law itself. And of course, specifics, make the change. Like you say, it's in the details eventually, and companies will have to not only make thorough gap analysis to adhere to the new requirements as well, they will also have to adopt compliance programs. Now, today compliance programs are, adopted usually by large entities, large companies, public companies, and they have a very thorough risk management. But now also, now it's not an option. Now everybody will have to do it, and of course, the compliance program. This is something that we know how to do. We are doing it already, but now we will have to expand it into to adjust it to the new requirements and also to adjust it to new entities that will need it, because it's just, small example for, if you want for illustration, we have the information security regulations for a few years, and de facto they added a lot of requirements to the statute already. But those requirements, sometimes they are being performed on material basis. Now, once you have administrative sanctions, if you're not complying with one of the requirements, then you cannot work on material basis anymore. You have to work on on a full basis of compliance. It's a different standard because maybe the authority, the regulator, at first they will give you a notice before they will give you a sanction, but you cannot rely on it, and you don't know exactly what their policy at any given time. So it's better to adhere to all the requirements. So it's a little different ballgame now, a little bit in that sense, which is good. It's good for the market. The market will be a lot more advanced, and it will give us much more protection also to data subjects. But I think that also data matters in general. So it's good for the market, and the market will be much more advanced. And I think that it will also strike the line with GDPR as well. And the new states, the new US states that are walking after California adopting new privacy laws. I think that everybody are talking at the same principles eventually. So it's very good thing, very good progress, for privacy matters in Israel and for Israeli market in general, because it's good for the tech industry and it's good for the economy. And we expect that it will, better protection on rights and better protection and you have a very substantiated clauses and statutes. So it's good for the market, it's good for business, and we hope for the best.
Yes, thank you, sharing. That's been very impressive. There are supposed to be there are many things that has been changed since the before the Israeli privacy law. So that's been very important to all the practitioners to do the work and together with the Israeli companies as well. So thank you for sharing. And for the next topic is also very important. As for the atmosphere, then between the Middle East is becoming so important at this moment, especially for the cyber attacking or disinformation and misinformation that you have been shared on the descriptions, especially for the platform company that's been a requirement under the Digital Service Act, the Digital Market Act. It's European regulations, but directly affect to the platform operations. So in the next topics, I'm gonna ask you about what the data protection action come out during the war against the cyber attack, and also that you have any legal moves since the war is coming, in recent actions.
All right. So thanks for this question. First of all, cybersecurity issues are very imminent, of course, and in Israel we experience a lot of cyber attacks from our enemies, and eventually you can see that there are many cases they are targeting Israel or Israeli companies, and Israeli public, and you can see it in social media, but you can surely sense it in cyber attacks. I think that in general, the Israeli companies are very well acknowledged with cybersecurity issues. Some of the most prominent cyber companies in the world are coming from Israel. Israel is a hub for cybersecurity, and there are a lot of examples. I'm not going to name them, but there are a lot of and very known companies that are working on cyber solutions. So in Israel, I think that every company has some sort of awareness. Almost every company, the awareness is very high in comparison to other places in the world. At least in my experience that I saw, Israeli founders, even in small startups, are very aware of cybersecurity risks, and they are making a lot of things that companies of this size are not doing usually in other places. I think that the law, by the way, the Israeli privacy protection law is supposed to, to give it, to make an effective legislation towards a better cybersecurity standard eventually. Because once you have information security regulations and you have enforcement, and you may be accused of negligence in case you are not protecting well the data, then there is a regulator to watch it. So eventually it helps to make this cycle in a better standard all the time, the good standard and the high standard all the time. I think that if you asked for a few legal aspects, so first of all, once you have a security incident in Israel, there is a reporting requirement. The criteria is that only if it's a severe security incident. You have all sorts of criteria mandated by regulations, but generally speaking, when you have a severe security incident, you must report to the Israeli Privacy Protection Authority. There is also the Israeli cyber department of the government. Usually, they are letting you know once you are being attacked or they found there is a leak of your information. So you're not supposed to be there in all the cases, but it's a very strong guardian that is also assisting the market. And two other issues that aside of the reporting requirement, first of all, preparations, directors, members of board, management members, they are all subject to personal liability if they are not protecting well the data assets and the personal data processed and being used by the organization. So first of all, you must make a very good preparation. It can be from a risk assessment, start from risk assessment, and move through cyber drills, and of course cybersecurity procedures, together with privacy protection, privacy policies. And this is something very important to have policies and procedures. And of course, if you want to gain a very good awareness of an organization, you have to do it all the time, not only during an assessment. And therefore, it's very important to have advisors, like CISOs, and if it's in privacy, BPOs. We of course provide. We lawyers usually provide DPO services and DPO related, privacy related advice, and cybersecurity advisors provide the security advice. And it's important to work together, of course. And those are my tips for now.
Yeah, thank you. In addition to the data protection, you described on your publishing about some misinformation and disinformation actions. So is there any kind of approach in Israel to prevent the some of the manipulative actions on the platform, something. It's not only for the legal, but also the some of the ideas to prevent these kind of things.
Are you referring to manipulation in social media?
Yeah, that's the very important in this scene in the like wartime that happens actually. In 9 months ago, we see that some of the news outlet that's been arising some of the questions. So, but that's the any of the legal answers from their perspective, or just struggling the how we can solve the problem.
I think that first of all, regulators are not addressing this issue in a good manner. I think globally, there are, if you're talking, for example, about chatbots or fake profiles in social media, I think that the big companies, the big tech companies, look at Twitter, maybe 40 or 50% of the profiles are fake, but they have a very good interest, a very good business interest to keep it because it provides traction and it provides a lot of income to companies that are making social media campaigns. And we can talk about billions of dollars that are invested in social media campaigns from all sorts of stakeholders, from commercial companies to political entities, and even hostile entities as well. So eventually, this is something that the big tech companies will never, I think, in my belief, they will never make a good treatment in this issue. It will have to come from the top, from regulators and lawmakers. I think that in the EU, they did a very, very interesting phase with the EU AI data, EU AI Act, that is regulating AI issues. And one of the prohibited things that they said is that cognitive manipulation is forbidden, for example. So this is a very good step forward. There's still there is something like a few months ahead until it will be effective, and let's see how the regulator in the EU will rise, if they will be ready in 6 months. I think that in other places it's a little difficult. In Israel, I can say that it's still premature, although the market is looking at the AI Act, and the market is trying to there is a beginning of a change towards looking at those principles and adopt them, or adopt the way they think. I think that this is, you can see it, but we're very far, I think, from actual regulations in that sense. There is, by the way, wide guidance of the Israeli Science Ministry of Science, that we do have some sort of guidance which is adopting the common criteria for AI use and deployment. But it is, first of all, it's a guidance, it's non-binding, and it's mostly for public bodies at this stage. But this is a start.
Yeah, thank you. That's very interesting actions. So as for the next question is about the new tech companies, because your law firm is supporting the startup companies as well. That's very important point to work on the data protection or other legal perspective, even though the small new tech companies at this moment. So what do you think the new tech companies have to consider in the AI and the data protection, the privacy from legal perspective to succeed in the business?
All right, it's a good question. Often been asked by founders. I think that you must be aware, and you have to understand first whether or not the business that you're planning is going to meet with privacy regulations. So the most important thing tip I can give is, to set a meeting with a privacy expert and to have a discussion over privacy by design. You have to be aware of privacy by design from the start to understand the red line, the boundaries, and you have to design your product and service that you are building according to privacy principles from the start. First of all, because this is the standard, and second, because this is the requirement by market, and third, because it will be much harder to change it, at a later stage. So privacy by design, this is something that you need to adopt at first, and I think that consultation call and a conversation. This is the best thing to do. I'm doing those all the time with founders and entrepreneurs, and we're having discussions way before they're establishing or incorporating the company itself. We're talking about the ideas at the ideation stage, and thereafter as well, we are going together once the product is being developed. So we're discussing it together, and then I think that the next time that we meet, after maybe something more concrete, is once you are going with a beta product and you're going to the public or going to the user, and then you need some documentation like privacy policy, and this is another step, that you need to another milestone you need to check yourself before you go out. So you have to make another consultation, and usually when we meet a startup to have a data protection impact assessment, usually it's a later stage after the startup raises enough funds. Usually it's between seed to round A, where it's starting to talk about assessments and the controls of compliance controls. And after round A, usually you can see most of the companies are coming to consult about assessments because it's already a funded company, you have a product outside, and when the risk is higher, and then you need not only to have a privacy by design consultation, but also you need to do actual things like assessments and controls, and to have a DPA form in place, or maybe to appoint a DPO, etc., etc.
Yeah, thank you. I agree with the designing phase. It's becoming so important to protect the fundamental rights. That's because the privacy by design is key part of the requirements for the startups as well. So in the end, I'd like to ask you about the last message for listeners. So you had a lot of things with the business side so far, then happy to share your message to listeners. So could you share about it here?
The message is that stay tuned for privacy compliance, and be aware of privacy by design. Most important principle, of course. And if you need any assistance, I will be happy to provide and assist. If you need any, reach out to Israeli market. And that's it. That's it.
Thank you. Thank you. Yeah, because there are a lot of the Israeli high-tech startups there. A lot of the company wants to collaborate with the startups. So you may have like good facilitators to bridge the regulatory perspective and business opportunities. So yeah, that's a Lior. It is a great conversation with you today.
Great. Same here. And thanks a lot for the opportunity.
Thank you.